All right, we got an interesting new case to talk about from the Supreme Court of Canada.
Yeah, it's a good one.
Yeah, it was in the news too, so people are like saying, oh, this is a big deal, this is a big deal. Got to tell you, when I first read it...
It is a big deal. I frankly think the dissent raises an extremely important point, and we're going to frame this for everybody. But you remember how we said the sky is falling with Kruk?
Yeah.
And people thought the sky was falling, and it really wasn't falling. In fact, every single time we're now drafting our applications and even closing submissions, we're using Kruk and referring to common sense.
Mm-hmm.
It's brought it back into fashion, right?
Yeah, I mean, the Kruk case is difficult for appeals, but for trials, it's been fantastic.
So this case is Rex v. TWW. It's a Supreme Court of Canada decision.
TWW 2024 SCC 19.
Yeah, it was just released May 24, 2024. Do you want to set it up with the facts so everybody understands, and then we can sort of talk about the decision itself and dissect it and talk about why there's some really important parts for this for everybody to understand.
There were two issues in this appeal. The first and the main one for the accused appeal was that there was a pretrial application to use evidence of other sexual history, and it was denied. And then there was a request to reopen the application mid-trial, and it was also dismissed on, which we can get into, stage one. It was a short-lived mid-trial application. So their grounds of appeal were mainly that they should have been permitted to adduce certain kinds of evidence, because in this case it was a couple that had separated, but they had, as the accused was saying, had consensual sex on the day prior to the allegation. And then she says the next morning she was sexually assaulted. And then it got really confusing, because he's saying, we didn't have sex in the morning, we had sex later in the afternoon. And that was consensual. And it was consensual. We also had consensual sex. So he had two different moments of consensual sex that he wanted to talk about. But then, of course, everything gets parsed out. And so they're saying, well, that doesn't relate to the morning, and the afternoon doesn't relate to the morning. Therefore, none of this is relevant for reasons we'll discuss. Right?
Yeah, so that's right. So the individual and the complainant, they were together for 20 years, and then they separate. And just like you said, even though they're separated, they were living in the same house. I can't tell you how many times I've said that's a recipe for disaster. And I'm not a family lawyer. We just get the cases out of family law.
They ultimately end up here.
They do. Look around. And for some reason, they have consensual sexual intercourse on April 1st. And then the next morning, she says, like you said, she was sexually assaulted. And you're right, it was a bit convoluted, but he wanted to put in the consensual sexual activity of April 1st, and he brought his 276 application in that regard. And it was dismissed, and the Supreme Court of Canada said, the appellant, I'm just doing this in short, Diana's going to go into some length, but just to frame it, so the accused appellant failed to sufficiently identify specific use for the evidence that did not invoke twin myth reasoning, and that was essential to his ability to make full answer in defense. So this isn't even anything that would be unusual under the new regime, because...
Right. So just because, even though we've described it before, twin myth reasoning means that you're absolutely not allowed to argue that somebody is more likely to consent or less worthy of belief just because they've had sex with you before.
Correct.
Or afterwards.
And this has been in place for a long time. So we often talk about our new regime that came in under Bill C-51. But this is under the 276 that's been in place for a long time. There's been amendments and changes.
Twin myths are like ancient almost.
But that's right.
Yeah.
They're ancient.
Everyone agrees the twin myths should be prohibited, but it's, yeah, and we'll get into the nuances of what people do or don't understand about how that works. And in fact, a number of lawyers, when decades ago, still had trouble understanding. They didn't even know the phrase twin myth, but now for lawyers, it's really common, right?
Yeah, it's like
so
like shirt and tie. I mean,
right?
Can you just address the in camera request on this one, which I find kind of offensive?
So we'll get into the details about that. But there was also a request from the Crown that the prosecutor in the States, they wanted the appeal to be held in camera. Now, the phrase in camera means the public is not permitted to attend, and it's sealed.
Which means the decision itself would not be available to the public.
Right. So in camera hearings for prior sexual history applications that usually happen prior to trial, or if they happen mid-trial, they are held in camera, because if the judge decides that the evidence is not admissible and that it's just salacious, or it's being used improperly or whatever, then you wouldn't want that evidence to be available to the public because it was impermissible, right? So there's a good reason for that. And then, but the trial itself and what the evidence that's allowed in trial is an open trial. Anybody can attend in person. You could order transcripts if you want to, if you're aware of it. You can't publish any identifying information, but you can still have access. You could attend in person, wherein the person takes the stand and says their name and spells it and all this other stuff, right? You're just not allowed to make that information public. But in-camera hearings are, nobody from the public can attend them.
Correct.
So this is a huge...
And nothing can be reported on.
This is a huge deal, to have somebody's appeal in camera where the public can't access anything to understand why somebody's appeal was won or lost. This goes into a phrase that when we were talking about this, you mentioned star chamber.
Star chamber, yeah.
So what is star chamber?
Star chamber is this horrible, there's a movie about it, but it goes back to where you would have this totally clandestine court, which would then review cases and make determinations about them without any public scrutiny or transparency whatsoever. And then those decisions that are made within this star chamber court would have incredible repercussions. So when you take it to the extreme with the movie and everything, they hunt down the accused who's found guilty and execute him. But the star chamber concept...
People can just disappear.
Literally. But the star chamber concept is a legitimate concept for us to remember. We live in a free and democratic society, more or less. Maybe less when that bill comes in with respect to the online laws. We have to tackle that one.
Don't even get me started on that.
Bill, is that Bill C-63?
I think so.
We got to tackle that one, because it's we could get in this podcast, but let's leave that alone. It's legitimate because closed societies, you see people being detained in Russia, detained in Iran, and other places where they have these fake trials. Mm-hmm. And it's really star chamber. There's stuff that goes on behind the scenes you
maybe
never
that
know.
Comes to my mind. Brazil.
I never saw that.
Oh my God. Okay. I'll forget you said that. By Terry Gilliam. Brazil. And it all starts out where they have
the only thing I know about Brazil was the cartoon Rio, which was fun. I used to watch with my kids, and the singing birds. It was really cute. Okay, go on.
Okay, I'll have to check that one out. But yeah, it's just
really good. The singing.
They have an office where they put a wanted person's name on, and there's a thing where somebody swats a fly, and then they mistype, and some guy gets his apartment raided, and then it's Terry Gilliam, his Monty Python, right?
Oh, okay.
But it is a really funny version of the star chamber kind of concept.
But it's real,
where people just disappear.
And in closed societies, and we have that. This is what goes on, and then we talk about we want more transparency. Well, our system's transparent. We don't have cameras in the courtroom like the United States, but anybody can come down and watch a trial, and you can get copies of judgments, and you can read, and everything is completely transparent. We need to avoid these types of appeals on issues that are held within these applications to be sealed. That's just insane.
Now, pause. Just slow down for a moment.
You're using my terms. I'm so proud of you.
I'm just thinking, that phrase, though, in camera, this is why it's so confusing for people, because it sounds like cameras are going to be allowed in the room, right?
Yeah, it's totally up. Yeah, it's a bad expression.
I don't know why they call it in camera, but this is what frustrates people when they're lay people trying to understand the law. You say, oh, it's going to be held in camera. Oh, great. There's going to be cameras. I can show up. I can take pictures. You know what I mean? That's what you would think. And, it's completely the opposite. And we're going to get into that a little bit further, too, about...
Okay, so this shows my ignorance.
The public faith in the legal system.
This shows my ignorance because I knew came from Latin, in chambers. It's a legal term, means in private. The same meaning is sometimes expressed in English equivalent, in chambers. So it's the same idea because we have in chambers motions which are generally not reported on.
And you know what I've said? Because lawyers are actually very funny, not just you, but many of them.
You used to say I was not funny. Do you remember that? You dissed me previously.
I did. But no, a good friend of mine, he actually was in court, and they said, oh, this is in camera, you have to leave. And he goes, I've been thrown out of better bars than this.
It's absolutely true.
And the judge said, I'm sure you have.
That's the other thing I like about our system sometimes. You can have humor in our courts and trials.
It disconcerts clients sometimes, though, because, and you get laughing about stuff with the prosecutors, and then they think, that's the enemy. And I was like, no, because, as we saw...
We've never lost a case
because
we've
seen
been
a number of times, these prosecutors are generally very fair and nice people.
Yeah, I mean, lately, the ones we've been dealing with have been just, I have to say, truth-seeking, sincere, honest, and really diligent, wanting to get at the right decision. So... And also, good sense of humor, and we're going to talk at another one about the police officers we had on this case. They were great. But anyways, let's go back to this appeal.
No, but the in-camera issue, though, you said today, it was like you're actually, because we've talked about whether or not cameras should be in the courtrooms, and you said you were starting to question whether or not you might change your mind on that issue, because I think they should be.
Yeah, so I've always been against it, and I've liked our system because I don't want it to see that anyone plays to the cameras. I don't want people to think they become celebrities. Like in the United States, you become a celebrity overnight because you have somewhat of a high-profile case, and then everything becomes so salacious and it's just blown up, and it's not. You really lose the truth. I believe you do. And there's a lot of cases that go on in the United States that are televised that nobody would ever know about because nobody cares about it, because it doesn't involve Johnny Depp. It doesn't involve former President Trump. It doesn't involve somebody of that nature. I do accept the fact that it does allow for more transparency and, frankly, more scrutiny about a lot of the injustices that does go on. And I was commenting in a minimal way about the Donald Trump trial in New York, about how they were describing, because in New York State, you're not allowed to have cameras in the courtroom. And it was kind of amusing because on CNN, they had like two lawyers, or like one of the anchors and a very good lawyer, and they were reading from the transcripts, and they were play acting what was going on in court, and it was utterly amusing. Like, I was like, oh God, really? But what they were trying to do was not just be able to talk about what went on, but give the actual texture of what was going on. Mm-hmm. And I saw that everybody was struggling and wanting that, and there was an argument. Dershowitz was saying this for sure, that they were not able to get across the unfairness of the judge's rulings against Donald Trump's lawyers, irrespective of what you think about Donald Trump, irrespective of what you may think about the case. There was like nothing going their way, which is pretty unusual. And Alan Dershowitz was saying that you just don't get an appreciation unless you have this televised. Right. And I said, look, that's a case I think should have been televised. Yeah. And I start to think sometimes here where you see certain cases, if the public were to really see some of our trials.
Oh.
First of all, we could write books and make millions then, and finally be able to retire. But you'd see the bullshit, right? Like, you would just see the utter bullshit. Well, and I think you would, and I think in a large extent you'd have some real confidence in our judges, with respect. I think you would, because nobody goes to read a decision.
I mean, I think it's really important because it's clear to me from especially some of the complainants, they watch too many movies, and I think it's important to see how court actually works. You could spare a lot of hassle and pain and and court resources if people understood that it doesn't work like the movies. And we're going to get into that in terms of, cause I'm going to get into that. Some of the cases we've worked on, it seems to me pretty clear that people have watched too many movies and really don't understand it.
And you also get how we catch, like in a case we did a couple of weeks ago, and I was going after the complainant saying, you were doing some research, weren't you? You were on that internet. You were trying to look up trauma-induced memory and shit like that, right? And you just sense it.
Don't even get me started on my body remembered, because apparently memories can be stored in your body parts instead of your brain.
We did a whole episode on that. I don't even think we broke 1,000 views on that one, because that was a good one. Anyways, so they made the right decision here not to have this in camera.
Right.
So
you can have publication ban stuff and redacted materials.
100%.
Materials, absolutely acceptable.
But no way should this have been an in-camera session.
No, we need to know why somebody was convicted and why it wasn't overturned, or why it was overturned. What's the point of appeals set help other lower courts understand how to interpret and apply the law.
Okay, so let's move on to the second topic, and I want you to discuss maybe a little bit about the majority decision, and then we're going to talk about the dissent.
Well, we say second topic, it was actually the primary.
Well, yeah, it's the primary one. So this is the most important one.
The actual case where why could he or should he have maybe been allowed to have adduced this evidence of other sexual history?
But I think it's important to frame the motion itself, why the majority ruled the way they did, and then we can talk about the dissent, and then there's the article you found where Lisa Defremont,
Defremont, I think it is.
A professor at Osgood had very good.
Forgive us if we're mispronouncing.
I'm very sorry for doing that. I could be chastised if I accidentally did that in a courtroom. But I'll leave that one for another day. But she has excellent comments about this, and this was also a decision.
Just to be clear, so Lisa Defremont, if that's how we're going to say her name, has written amazing articles helping people to understand what's a stereotype and what isn't.
Her articles are excellent.
Yeah, and how to decide if something has probative value, or if it's actually one of those twin myths that we were talking about. So she's an expert in this. She's been cited by the Supreme Court numerous times, and it's fantastic that they interviewed her in this article. And that's just the background for who she is.
Yeah, and we'll fill that in. But her articles, we quote them in our materials. So it's Justice Pachaco and I think Professor
Sorry, I had to do that.
Both of them have written excellent articles that has really been able to distill, these principles in a very good way. But
how to separate out what's legitimate and what isn't.
Yeah.
Right?
So the majority decision was written by Justice O'Boswin. This was her first judgment, and it's absolutely understandable, well-written judgment with 7 judges who are in total for the majority. So, but they missed something that's really important. So lay out, please, the summary of the majority decision, and then let's go into the dissent and why we are criticizing the majority decision.
Okay, well, first of all, I didn't have a problem with them saying that your application needs to be very specific and detailed as to why the evidence is relevant to an issue that's live at trial. That's, to me, common sense. So I was just like, why is this a big deal? What I did get concerned with was that they quoted another case and used some pretty extreme language, saying that the evidence had to be, to the extent that without the evidence, the accused's testimony would be untenable, or sound absurd, or something like that. Extreme language like that. And it was like, no, it just has to be probative. It just has to be directly related to an issue, and the weight to be, determined at trial, not at a pretrial motion. And I was really concerned about them raising the bar on. It was like, I'm sorry, you have to prove that this evidence is absolutely essential, and like dramatic words. But then they go on to say, but if it contradicts something she said, that's totally a good reason to use it. And they go on to say that, but we have seen that prosecutors latch on to these specific paragraphs and then try to block our applications.
Or complainant's counsel.
By taking it out of context. So if you look where they use the word untenable and you go to Goldfinch, the context was missing, right? Yeah. So I think did you bring Goldfinch?
I did. Let me just frame this then, because everything you said is important. So the majority decided that the trial judge's determination to admit or refuse evidence on the 276 application as drafted by the trial defense lawyers of other sexual activity on appeal must ensure that the trial judge applied the correct legal principles, considered all the evidence they should have, and did not admit irrelevant evidence and did not otherwise err in law. No deference is owed in that regard. However, as the trial judge's determination that the evidence's prejudicial effects substantially outweighed its probative value, the appellate courts should defer. So what they were saying is...
You sound like a robot. Slow down.
Sorry, but what they were saying was the judge's decision based upon...
For us,
this analysis should be given deference because the trial judge was in the best position to determine the prejudice versus probative.
Right.
And they specifically then re-emphasize other sexual activity evidence must be admissible in relation to issues of credibility or context, but the applicant must establish, as you said, a specific use for this information that's permitted by the Section 276 regime, and the applicant bears the burden of establishing that any such probative value is not substantially outweighed by prejudicial effect. Specificity is required so judges can apply the scheme in the way that protects the rights of the appellant and the complainant and ensures trial fairness. There must be sufficient factual and evidentiary basis for the trial judge to properly consider and weigh the factors out in 276. So it's the applicant that must demonstrate, this is where it is, the applicant must demonstrate that in the absence of the evidence, the applicant must demonstrate that in the absence of the evidence, their position would be untenable or utterly improbable.
And I want to explain.
Go, girl.
So people, who have been accused of something, they always say, "Oh, well, the burden's on the Crown. The burden's on this." This is important. Like you said, the burden is on the accused person to prove that the evidence they want to use and the questions they want to ask are probative. So at trial, yes, to be convicted, the burden of proof is on the Crown. But in a pretrial application, the burden is on you. They just think, well, I can just say anything I want to. No, the burden is on you to prove what you want to say is relevant. And that is actually a point I don't think we've really articulated well enough before. People who are accused need to understand you can't walk into court, and this is especially important for people who are in family court, because in family court, you walk in and you make an affidavit, you can say anything you want in your affidavit, right? Yeah. You go into criminal court, you're not allowed to just spout off at the mouth. You can't say anything you want to. You need to literally get permission, and to get that permission, the burden of proof is on you to explain why it's important.
That's an especially important point.
Suck that up, Buttercup.
No,
because if you've been accused, this is what you're dealing with.
Yeah, no, I think we've tried to mention before, and I got to give a shout out. I spoke last week to a bunch of lawyers from Calgary, criminal defense lawyers. We had a little, CPD. It was very kind. I'm just saying thank you very much. It was very kind to invite me to speak about topics that come from our podcast. So it was really lovely and really affirmative to find that this is of interest to fellow lawyers. And we're so delighted to help and to give information, because we're really just sharing our pain. And somebody said something really interesting on it about jury trials that I'll discuss with you later in another episode. Okay. He's having great results. So I'm like, maybe I got it all wrong about picking a jury, but it was interesting. So, the lawyers who are watching this program will understand this, but it's very important, like you said, for accused people to understand on these motions, they bear the burden. They have to establish it. Even though that threshold is not as high as the Crown
and complainants
counsel want to argue, it's still a threshold.
There was a really interesting thing.
Can I just back up for 1 sec? Can I just close the loop?
You can do whatever you want,
so,
Joseph.
That's from a lawyer who I was at an inquiry with. He was a brilliant lawyer who was a commission counsel. He would say, "I'm going back to close the loop." He was French, and he became a judge. Anyways, so where does that language come from, Ms. Davison, about in the absence of the evidence, their position would be untenable or utterly improbable? And this language is, I think, dangerous, because people can take this out of context and go, well, that just means that their argument has to reach such a high threshold. What?
I was looking, because you have Goldfinch. You're asking me
right,
to answer the question. But
I know.
So, okay. It was like, well, I don't know.
You have paragraph 66.
I don't know, Mr. Neuberger. Paragraph 68 is
Go to
what they were
67 and
quoting
68.
So paragraph 68 is where they get the words untenable and
improbable.
And improbable. Utterly improbable is the phrase. But you have to understand it by the context of what they were talking about in this case. So in this case, paragraph 67 of R.V. Goldfinch, Supreme Court of Canada, you can look it up, is pretty easy to find.
We'll have it on the screen.
Before this court, Goldfinch sought to articulate specific issues which made the sexual nature of the relationship critical to his defense. He advanced that his narrative would be inherently improbable. So this is the accused saying, my narrative would be improbable if the jury can't hear that he was friends with benefits with the complainant. Among other things, he argued the evidence was relevant to the jury's assessment of her call to him, saying that there was some birthday sex being owed, and as well to his testimony that she smiled when he mouthed the words.
Right.
People.
I'm sure everybody can read lips on the...
In my view, there's nothing about Goldfinch's testimony that casts him in an unfavorable light or renders his narrative untenable or utterly improbable absent the information that they were friends with benefits. So that's where those words came from, is that they were directly addressing his grounds of appeal.
It was specific, was it
saying
not?
Saying that he said, it would be improbable or untenable. And they're saying, I don't see any reason why it'd be improbable or untenable without that. So now those words have been taken and used in a scary way in this new decision.
We think scary.
It sounded to me scary. I mean, they go on to make it clear that things can be probative.
They do. So it's interesting. So the applicant must demonstrate with particularity not only the credibility or context is relevant to an issue at trial, but that in the absence of evidence, their position would be untenable, utterly improbable. So let's dumb this down for a moment, for me. The argument then would be the narrative that I'm putting forward without this evidence, what I'm trying to say would just seem insane. Okay? Mm-hmm. So then really it's not such a high threshold, it's quite a low threshold.
But we know from Harris that the evidence only has to make something more or less probable.
Correct. Right? And
there's a case called Harris.
Yeah, it's Regina versus Harris, and it's about where there is a complainant testifying about characterizing a relationship in a particular way, and you need to rebut that in order to demonstrate what the true circumstances were. Well, that doesn't mean that it would reach a threshold that without that evidence, it would be improbable. There would be no coherence. Mm-hmm. That's my concern about extending the terminology that's used in paragraph 68 in Goldfinch to many other cases without specific reference. And it's interesting because they talk about Regina versus Crosby, 1995, 2 SCR 912, which is a case we often cite, and it's exactly what we're saying. And so in that case, writing for the majority, the court held that the judge erred in excluding the evidence because the starkly opposing versions of events testified to by the complainant and the accused placed credibility as the central issue at trial, and the complainant's statements presented a material inconsistency. Balancing the probative value against the prejudicial effect, the interest of justice favored admitting the evidence. That's all you really need to say. Mm-hmm. So then they come back and they talk about this.
No, this is important though, because credibility, constantly people saying, you can't challenge a complainant's credibility because that's a twin myth. And it's like, no, it's actually central. You just can't challenge credibility because they happen to have had sex at some other time. Or
100%.
Or they sent sexualized messages.
Absolutely correct.
But credibility is always
a central issue. And they go to Crosby, and I think we spoke about in a couple episodes before about a specific case where they said credibility is a central issue. Stop, and they overturned and sent back for a new trial. So in addition, they referred to Harris, which is what we spoke about. 1997, 118 CCC 3rd 498 Ontario Court of Appeal.
I want to just pat myself on the back for remembering.
Very good. So the accused and the complainant met at a bar several days before the alleged assault. Allegedly. See the cup? The complainant testified in chief that her relationship with the appellant was, I think I need new glasses, was platonic. It's even better without it. That they had not engaged in any sexual activity, and that she told him she did not want a sexual relationship. The accused sought to deduce evidence of an alleged consensual sexual encounter several days before the sexual assault. By failing to permit the appellant to lead evidence of the Tuesday night incident, the jury was deprived of the tools needed to fully and fairly assess the conduct of the parties and the believability of their respective positions. Left unchallenged, the complainant's testimony concerning her relationship with the appellant was potentially devastating to his position. Stop. That's the law. We need to remove ourselves from that language from Goldfinch. It was highly specific.
It was case specific, and that's one of the things they always say is that all of these, decisions, in terms of pretrial applications, are very case specific. And the problem is that the wording ends up being taken, and if you leave out paragraph 67, you lose the context.
Right. And this is a very good caution, because I think we have to fight against, at least from our side, this untenable or highly improbable. It's not really helpful. If credibility is a central issue and a complainant test in a certain manner directly contradicting what the nature of the relationship is, which would allow your client to be able to testify in a coherent manner about why their defense is what it is, that has to be allowed. Otherwise, a trier of fact would be left with a skewed version of events, and you cannot have a fair trial. Now, let's go to Professor.
I know. So there's quite a few. Most of the quotes in here are, everything she has to say is really relevant.
I think just quote her, because the article isn't well written.
So she's talking about how the majority's reasons were straightforward, clarifying, the law as everybody understands it. So there's no real problem with the decision. But she says, there was an argument for relevance of other sexual activity evidence if the complainant was leaving the trier of fact, being judge or jury, with the impression that at this time in their relationship, she never would have had sexual interaction with them. So if you recall what we said about this case, they were living in the same place but separated. They had sex on day one, and then he's accused in the next morning of sexual assault, and he says they had consensual sex in the afternoon the next day. So, but she left the impression at trial testimony that there was no way she would have had any interactions because they were separate, right? So then the previous sex would become relevant. So Dufresne was saying, this is the impression they were left with. She never would have had sexual interactions with them when she admitted to having done so the day before. And then for a little bit further down, it says, there's a worry that the accused may have been let down by his lawyers in not putting forward what was really the best argument for the admissibility of the evidence. But I can certainly understand why the majority of the Supreme Court decided why this was beyond the scope of the appeal. And so this is one of the things that disturbed me about this case, was that in some ways this decision became about words and not about fair trials or justice.
Words and what's reviewable on appeal.
Right. So they're saying because the application may have had some probative, there may have been some probative value, they didn't articulate it properly, therefore...
And it wasn't argued on appeal.
And, well, yeah, it gets even a little bit weirder because it became about what the dissenting judge specifically used in the words of his dissent and whether or not it was before the Supreme Court to consider that. And that's because there was the mid-trial application that came up. So the dissenting judge said he thought the original application should have been granted or revisited, but he didn't say the mid-trial application was mishandled. So the Supreme Court just went, yeah, we're not going to look at that. We're just going to leave that alone. Even though it may have been a legitimate ground of appeal, they said, it's not before us, so we're not going to consider it.
Pause. Now let's go to the dissent. Okay? Because this is the crux of what disturbed me. I gave it a quick read on Friday, and I got concerned about it. And a certain reporter who does a lot of writing on, I think the only one who really does writing.
Yeah.
A media reporter was asking my comments on it, and I didn't get a chance to articulate everything because it was running out. But this is what caught my eye. So the dissent by Justice Cote and Moreau stated...
Cote is like the absolute top dissenter.
Yeah, I know, and you really like Justice Cote. And
she's a fighter.
Yeah, she's a toughie. She's spunky. We agree with our colleague's disposition of the Crown's pre-hearing motion. We take no issue with her conclusion that the courts have implied jurisdiction to control their own processes. We further agree that the trial judge did not err in his initial pretrial determination on the voir dire under Section 276. That's the hearing. The trial judge made appropriate findings on the evidentiary record available to him at the time of the voir dire. However, we are of the view that this conclusion does not end the analysis. In the incident case, the central issue in trial was credibility. Okay, so again...
Confirmation. Credibility is a live issue at trial.
Yeah. The complainant's testimony evolved from her first statement to the police to her trial testimony. Following the trial judge's ruling on the 276 motion, would have left the trier of fact with the mistaken impression that the circumstances of the separation and her belief that the appellant was in a relationship with another woman made it unlikely and improbable for her to consent to sexual activity with him. The evolution of the evidence should have prompted the trial judge to revisit the 276 ruling made at the pretrial stage. As we will explain, trial judges have an obligation to revisit their previous rulings when there is a material change in circumstances. In light of the complainant's trial testimony, and this was testimony in chief, the trial judge should have allowed the appellant to cross-examine her about the consensual sexual activity that took place between her and the appellant the previous evening for the limited purposes of neutralizing the suggestion that she was unlikely to consent to sexual activity after their separation and testing her credibility on that point. In failing to do so, the trial judge committed a reviewable error. As we will explain below, we are of the view that the issue is within our court's jurisdiction, the Supreme Court of Canada. We would therefore allow the appeal, quash the conviction, and order a new appeal. Just give me 2 more seconds and I'll stop, okay? Because I know the language is sometimes a bit boring.
I'm trying to keep in mind the points I want to pick up on. You said obligation. I just wanted to clarify, it's not just the judge has an obligation to think, hey, I think something's changed here since the ruling, but they don't require the defense to ask for that ruling. They have an obligation to keep in mind whether circumstances has changed. So just the fact that a defense didn't necessarily ask for a mid-trial ruling doesn't mean that you can't appeal that.
So that's a very important point, Diana, and you're emphasizing it. So let's just go back. Trial judges have an obligation to revisit their previous rulings when there is a material change in circumstances. In light of the complainant's trial testimony in chief, the trial judge should have allowed the appellant to cross-examine on and on. I'm not going to repeat myself. So what you're saying and what we're saying is the dissent here takes a broader view of the role of a trial judge in controlling their own process. It's not just simply saying...
With what in mind?
It's not...
A fair trial.
A fair trial and a truth-seeking process. So it's not just saying, hey guys, do you want to bring a pre-trial application, mid-trial application now?
It's not about words and paper.
It should be.
It's about fair trials.
It should be to say, okay, hold on. I ruled on a pre-trial motion. Now the evidence has changed. I can't let this go. Regardless of what the defense...
We've seen that. I mean, we don't have to be reminded of it. But we've seen judges point it out on their own. And that's...
And in this case...
They should be alive to it.
And in this case, the defense lawyers were alive to the issue and brought the motion. Let me just say one other thing. What's interesting is how they disagree. I don't do many appeals. Our office does, but I specifically only do a few. But they raise something interesting here, and it's... The dissent found that, let me just make sure I get this correct.
I'll pose in the meantime.
Let me just emphasize this. These statements suggest that it was unlikely that the complainant would consent to sex with the appellant in light of their separation, blah, blah. The April 1st evidence provided crucial context to their statements. I just wanted to say that as well, because it's not just credibility, it's neutralizing the statement, as they say, and also crucial context, all of which are not bad words. And what they were also trying to say was that the reviewability on appeal, if I've got it correctly, was that error by the trial judge not to allow the mid-trial appeal was a reviewable error that should be determined on the standard of correctness.
Right.
And I'm pretty sure I got this correct. And that means that they had an obligation, the Supreme Court of Canada, to say, no, they f***ed up. It has to go back for a new trial. Period.
Yeah.
So I hope to see this dissent be developed for future appeals on this very issue, because I want to see developed, or I would like to see developed, that there is a role for the trial judge, and a lot of trial judges do this extremely well, that they will sense something that's going on, they will get it, and they'll flag it.
So overall, there's nothing really disturbing about this decision because it really just confirms what everybody should know, which is you have to detail out why you want to use certain things, right? It's not that difficult to understand. Maybe a little bit. It takes time and effort to do properly, but it's not that hard to understand. But and then also they made a really good decision to deny an complete in-camera appeal, but to make that sound. But also, I gotta say, looking through this, there's so many cases that have so much, kind of graphic detail to them and stuff. Why this case? There's nothing about this case that makes me understand why they would decide to try and change the law on open courts with this case. It just seems bizarre to me.
Yeah, I know. We're getting we've argued on applications about the term flirting. We get to a point where I was being a bit indignant.
Apparently flirting is the new, common sense, is a forbidden word. Oh, flirting. Oh my God. How dare you say this person was flirting? I was like, what does flirting mean?
We can, as I've tried to say, we can get to a point of absurdity with all of this. Yeah. And what you're trying to say is there's nothing particularly...
It seems like a policy change that they're trying to get through, some sort of instead of going through Parliament saying, certain things and having votes on it. It seems to me that this is just an action that's like somebody wanting to change the world. Because that's a huge thing to make appeals so that they're closed off from the public. That's
about
crazy.
276 issues. So it's not about a sex assault in general. It's about the 276 issue and how that factored into an unfair trial and blah, 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 and it should be a retrial.
Then how does anybody else learn from the decision if you can't read?
No, I agree. I think there's nothing particularly
about this case.
Bizarre. Just nothing. Publication ban was sufficient. And then I applaud the dissent because they actually went back to the parliamentary discussions about the amendments and then about how you deal with 276 and on the reading of the new provisions that they come to their decision about the standard of correctness based upon just how crucial this evidence can be and how strict that analysis is. I would encourage and I hope that if we're in these circumstances that it's something that gets pushed and developed more, because it's very important that if there is this type of error, it's whether it's properly before the appellate court, they must consider it. Otherwise, the trial judge, and I would urge, if there is a material change in circumstances and testimony of a complainant, therefore creating a material change from the actual motion, there's an obligation to reopen it.
I know. And in reality, and if the judges who are hearing an appeal or the judges who are presiding over a trial, if they think of something, they can just ask for submissions on it if they think it's relevant. There's no reason they can't consider it. I know.
We've had that happen, and anyways, I think this is an interesting case, and I just think the expansion of the term improbable, untenable. It's not yes, it's there. Yes, you can use it.
Go look at the source and get the context.
But just look at the source. When you've got cases like Harris, and you've got cases like Crosby, and you've got all the other cases that talk about credibility, you really don't need to import other language that may be confusing, in my opinion.
I know.
Thank you.
And you can go look this up on canley.org, the citation. You can actually go read the entire thing, and we encourage you to do that with all the cases we talk about.
So, Pillow Talk.
Oh, right. Don't forget to like, comment, subscribe, share, tell all your friends, and
send us comments.
Send us comments
and
because
emails.
We love that. Yeah, and
we love the interaction. Again, it's like it was so much fun talking to the some of the criminal defense bar in Calgary. Just this type of engagement we love. So thank you so much for that, and let's do more of this, because this really enhances all of our understanding and how we work together to teach each other and to be better lawyers and to really try and get fair trials and fair decisions.
If there's something you want to know about the law, just ask us.
Yeah. Okay. Good night.